We have breaking news out of the state of Colorado. The state of Colorado's law that prohibits the sale to 18, 19, and 20-year-olds in that state has been upheld effectively by a 3-judge panel of a Clinton judge, an Obama judge, and a Biden judge. In a relatively sloppy 95-page set of decisions, 3-0, the gun control law has been upheld. No real shock here. The reasoning is pretty sloppy. We're going to go over it. We'll discuss it. Not particularly precedent setting here, but of course it's an anti-gun decision by judges that you would expect to come out with this result. Let's break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the new article, the law review article in the Georgetown Journal of Law and Public Policy entitled Dangerous But Not Unusual, Mistakes Commonly Made by Lower Courts in Post-Bruin Litigations. Check it out. I'll link to the article down below. Very detailed analysis of how to understand the Second Amendment, how to apply the law, the text, the historical analogs, and so on. It's about 80 pages long or something like that. Check it out. It's totally free. Georgetown Journal of Law and Public Policy, associated with the Georgetown School of Law. All right, folks, so we have a 90-some-odd page decision in a case involving the Rocky Mountain gun owners against effectively the state of Colorado and all the people engaged in the enforcement of gun control laws out there. Dealing with the law that was enacted in 2023, this is 18, 19, and 20-year-olds cannot acquire guns privately or through FFLs out there in the state of Colorado. This law was challenged. It was initially enjoined in a preliminary injunction. It went up to the 10th Circuit Court of Appeals, the 10th Circuit, and in a 3-0 decision with an Obama judge, a Biden judge, and a Clinton judge, the last 3 Democratic presidents, in a 3-0 decision, the gun control law was indeed upheld. This was a shock to absolutely nobody that this panel in a 3-0 ruled in this manner. Now, they put out 95 pages of language and text and argument, not particularly compelling. And I'm going to give you the rifle shot why a decision upholding the law, this is 18, 19, and 20-year-olds cannot acquire firearms, is fatally flawed with one simple point. Nowhere was I able to find in this 95 pages of rhetoric and discussion by these judges any reference or citation to the Militia Act of 1792. Now, you as viewers of the Four Boxes Diner Second Amendment channel here would absolutely say that the first law that one needs to contemplate, if there's a discussion of whether or not 18, 19, and 20-year-olds are entitled to engage in the right of the people to keep and bear arms, is you go to the time of the founding and ask yourself, well, what does the law look like back then? Well, we know from the Militia Act of 1792, enacted 1 year, maybe not even a whole year, but 1 year after the ratification and effectuation of the Bill of Rights, including the Second Amendment's right of the people to keep arms. A year later, Congress enacts a national law, not a state law, a national law, the Militia Act of 1792, that specifically, expressly provides that members of the militia are ages 18, you heard what I just said, 18 through the age of 44, which would include, I know you don't have to be an Oxford Don for this one, but that would include 18-year-olds, 19-year-olds, and 20-year-olds. That's right. So you have a founding era law, 1792, that says 18, 19, and 20-year-olds are in the militia. And why is that extra important? Because that same federal law, which applied to the entire country, said that those 18, those 19-year-olds, those 20-year-olds at the founding had an obligation to bring with them to militia musters what? Their very own privately owned firearms, their very own privately owned ammunition, their cartridges, their containers, their weapons. So please explain to me, Bueller, how an 18, 19, and 20-year-old would have an obligation to show up for militia duty under a federal statute that applied to the entirety of the United States at the exact same time period of the enactment of the Second Amendment. Exactly how are 18, 19, and 20-year-olds in 1792 going to be able to bring with them their own weapons, their own firearms and ammunition and the like to militia musters if they cannot acquire them in the first place? Because of course they could acquire them in the first place. The militia was 18-year-old all the way up to 44, including the relevant time period. And somehow, the intellectual giants of the 10th Circuit somehow failed to mention or cite to, never mind discuss or distinguish, the Militia Act of 1792 and the fact that the exact same people, the exact same age groups being discussed in this Rocky Mountain gun owners case are covered by that federal statute in the year of our Lord 1792, and that somehow gets skipped over by this Biden judge, by this Obama judge, and by this Clinton appointee. Coincidence? I don't know. You tell me. So nevertheless, the fact that they couldn't be bothered to even address and consider this obvious relevant law, what do they discuss? Well, they seem to hang their hat on this language about that nothing about these Heller decisions, the McDonald decision, or the Rahimi decisions, or the Bruin decisions somehow are impact rules about commercial transactions or conditions on commercial transactions. As if the fact that you're banning somebody from being able to buy or sell a gun, which yes is a commercial transaction, as if that somehow excuses you as a federal judge from engaging in the Bruin methodology. So they put too much weight on this dicta language about presumptively lawful rules involving qualification and rules associated with the acquisition of firearms. But all that dicta does, and all the dicta generally does, is to say, as a general matter, this particular case is not dealing with that specific issue, so don't interpret it as such. But nothing, of course, excuses the court, the lower court, from having to engage in the Bruin-Heller analysis of text first, burden shifting to the government, and then historical analog analysis. Well, the 2-judge majority, it was a 3-0 decision, but there was a concurrence by Judge McHugh. There was a debate as to whether or not the text was even implicated here. Well, it's not that hard, folks. The text of the Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed." Heller's defined all these terms. It defined the people as anyone associated with the national community, which obviously includes all Americans. Because all Americans, even Americans under the age of 18, mind you, have constitutional rights. We don't have to look that far for this because we know that 18, 19, and 20-year-olds have the right to vote. We also know from well-established black-letter constitutional law, cases like Tinker versus Des Moines, that even teenagers have constitutional rights. And certainly, there are plenty of people under the age of 18 that engage in gang-related activity and criminal-related activity that absolutely benefit from the Fourth Amendment and the Fifth Amendment and these other criminal procedures, the Eighth Amendment, cruel and unusual punishment. So we know that the people include all Americans, including those under 18, and thus, by extension, they obviously would include 18, 19, and 20-year-olds. And we know that the right to keep and bear arms means the right to possess and the right to carry them for the purposes of self-defense. So somehow, 2 of the 3 judges raised the issue of whether or not the Second Amendment protects the right to acquire a gun. Because it's implied. Well, of course it does. It's not that hard. There are what's known as concomitant rights. This is discussed. The court references it. It's not that hard. Just think about it. The Supreme Court has said unequivocally that under the Second Amendment, you have a right to keep and bear arms for the purposes of having the weapon in case of confrontation, for the purposes of self-defense. Now think about it. Does the word tyranny appear in the Second Amendment? Does the word self-defense, do those words appear in the Second Amendment? Does hunting appear? Does animal attacks appear? No. Because it's implied. It's implicit. It's a concomitant right. And the Supreme Court said that the right to self-defense is essential. It is the right, in a sense, protected by the Second Amendment. So my question is, how is it possible you can read the text of the Second Amendment as not including a implied ancillary or concomitant right to acquire the guns? How else are you going to be able to exercise your right to keep or to bear arms if you cannot acquire them in the first place? So obviously, as a matter of text, it's absolutely implied within the text as an ancillary right, the right to be able to acquire firearms. Which means that if you pass a law, which Colorado did here, that says that 18-year-old Americans, 19-year-old Americans, and 20-year-old Americans cannot acquire guns, that obviously implicates the text of the Second Amendment. And once the text is implicated, the burden shifts to the government. To do what? To show there's a long-standing historical tradition going back to the founding that justifies the law. But here, 2 of the 3 judges actually said you engage in the historical analysis at the textual level. But that's hooey. Because what is text? Text is text. What does that mean? What is text? Text has a meaning. It's defined. How do you define it? Dictionaries. It's not that hard. And guess what? When it comes to the Second Amendment, we don't have to think that hard because the Supreme Court has done all the work for us. If you look at the Heller case, they literally defined for the lower courts that people mean all Americans. That the right to keep means the right to possess. That the right to bear means the right to carry. Not that hard. It's already in there. That arms includes anything that's a bearable arm that can be used offensively or defensively, which obviously by extension includes handguns and firearms. That's what Heller said. Yet these judges in this case go out there and say, well, we have to look at the history of all this. No, you don't. Why is it, of course, these people treat as the gospel dicta from Supreme Court precedent, but they simply skip over and refuse to simply just apply the definitions without questioning given to them by the U.S. Supreme Court of the key terms of the Second Amendment? Because they don't like the answer. They don't like the fact that if you follow the Supreme Court precedent, you rule in favor of 18, 19, and 20-year-olds as a matter of text at least. But let's go on to the second level. The historical tradition of firearms regulation. Who bears the burden? We know who bears the burden. It's the government. Now here you have the judges, by the way, are talking about how, well, arms are only protected if they're in common use. They got to be commonly used, and that's a textual issue, and the plaintiffs have to bear the burden of this. No, they don't. Where does the notion of in common use come from, folks? If you watch the 4 Boxes Iron, you know what I'm about to say. The notion of arms, the definition of arms as a textual matter at the first level of analyzing in Heller and Bruin, as a textual matter, an arm is nothing more than something that can be used offensively and defensively, and it's bearable. I mean, you can carry it. If you can carry it and you can use it offensively or defensively, it's an arm under the text of the Second Amendment. So where does the in common use test come from? Where does the commonly used language come from? It's not that hard. It comes from the historical analysis. Here they just said the historical analysis of historical analogs in Heller. It comes from the history part of the text first, history second. And why is that so important? Because the burden is with the government at the historical part of the analysis. Which means it's up to the government to show that arms are not in common use, that they're not commonly used. Did this court do that? No, it did not. Sloppy poppy, but not a shock. Not a shock. Not a shock here. Moreover, there's discussions of various laws. Remember, we talked about this. The relevant time period is the founding era, because to understand history, you need to look at the time that a law was enacted as to what the people that enacted the law were thinking. This is not Mark Smith in the 4 Boxes Diner. This is what the U.S. Supreme Court has said, that to understand the Second Amendment, you got to look at when the Second Amendment was adopted as to what they were thinking they were doing when they adopted it. It doesn't matter what a 21st century law professor says about the 1792 document. You go back to 1792 and try to figure it out. And that's what the Supreme Court did, using 1791 and 1792 dictionaries, both in England and the United States, to define the terms. And again, this decision doesn't even talk about the ultimate law in terms of 18, 19, 20 years, the Militia Act of 1792. No, instead, if you look at what, for example, Judge McHugh's concurrence here talks about, she's literally talking about laws from 1900 up to 1933. She is talking about 20th century laws that the U.S. Supreme Court has literally said is verboten. It's too late in time. What on earth is a 20th century law going to teach us about the understanding of America's founders in 1791 when the Second Amendment was adopted, or 1792 when the Militia Act was? No, she's talking about, these judges are talking about 20th century laws and the fact that in the 20th century there were rules and restrictions. In the late 19th century there was rules and restrictions on 18, 19, and 20-year-olds being able to carry guns. But here's the thing, folks. Remember the purpose of the analogs that you look at, the historical analogs that you look at the time of the founding. What do you do with them? You look at the how and the why. And then what do? You look at them, you analyze them, and if there's a sufficiently large quantum of them, and they're representative, and they cover the bulk of the country, let's say, you draw a principle of some sort from those historical analog laws. But the first thing is there's only one historical analog law that covers the entire country that would trump all. That's the Militia Act of 1792. And that says that 17, 18, 19 years had a duty to bring guns with them to militia duty. And they had to acquire them in the first instance, which obviously is strong historical evidence that I don't see how the government can overcome. That 18, 19, and 20-year-olds are entitled to full-blown Second Amendment rights at the time of the founding, just like anybody else. And here's the thing. The anti-gunners come forth with evidence saying that minors did not have Second Amendment rights or did not have the right to keep firearms at the time of the founding, and minors were people that were under the age of 21. Here's the key. Footnote number 11 of Bruin breaks the tie, and do these three judges, the Obama, Clinton, and Biden judges, do they mention footnote number 11 of Bruin? Do they even read footnote number 11 of Bruin? I think not. But if they did, what would it say? It would tell you that where there is a historical ambiguity, meaning there's an equally good argument for freedom and an equally good argument for no freedom, let's say, there's a debate about what's correct historically. The Supreme Court said in Bruin that you are to opt in favor of the text of the Second Amendment, which is the unqualified command. So even if you assume for the sake of argument, there is a bunch of historical laws that suggest that 18, 19, and 20 years at the time of the founding had no Second Amendment rights, you at a minimum have an ambiguity because there's no other way to explain the existence of the Militia Act of 1792. And if you say, well, these other laws are here, what have you done? The only thing you've done, for crying out loud, is create a question mark. An ambiguity, which means there's one or more reasonable interpretations available that may be pointing in contradictory directions. But again, if you look at footnote number 11 of Bruin, it says if you have a historical ambiguity in the record, which arguably you might have with the Militia Act of 1792 in favor of freedom and these other analog laws against freedom for the sake of argument proffered by the anti-gun experts and by these judges, the best you've done, if you're an anti-gunner, if you're the government, is you've created an ambiguity, but that is not enough to satisfy your burden, because as the Supreme Court said in Bruin in footnote 11, the burden of the government is to clearly show they win the case historically, and if they don't do it, and all they do is create a tie or an ambiguous situation on the historical record, they lose. Don't believe Mark Smith. Look at footnote number 11 of Nysurper versus Bruin. The U.S. Supreme Court says it about the Sir John Knight's case. It's not rocket science, folks. It's not rocket science. Judges on the 10th Circuit Court of Appeals. Okay, so to wrap this up, this 3-0 decision was against the Second Amendment. They basically said the preliminary injunction that enjoined the law is vacated no more. They refer this case back down to the lower courts for further proceedings. This is not something that's going to go to the Supreme Court because it's on an interlocutory basis, because it's a preliminary injunction. It's just kind of the way it is. But again, I think there are other 18, 19, and 20-year-old cases that are likely going to be to the Supreme Court. Before this one, probably the Reese case out of the Fifth Circuit. We'll see what happens there. But nevertheless, yeah, I don't think this is a particularly compelling decision. I think it was just they phoned it in. They wrote a bunch of words, but I don't think it's going to be particularly important in the history of American law. But again, I'll put a link to it down below. If you want to read the 95 pages, go right ahead. But again, I think at the end of the 18, 19, and 20-year-olds will be found to have full-blown Second Amendment rights. I think that's exactly what the Supreme Court will say when they eventually take such a case. All right, folks, there you have it. I hope you learned something here today. Make sure you follow me on X at 4Boxes Diner. Make sure you like this video and share it widely. And don't forget to subscribe. We're trying to get to 200,000 subscribers here on YouTube. And we'll talk to you again very soon here at the 4Boxes Diner.
Orders up. Table 2A.